This is Marco Brown with Brown Law. I want to take a few minutes today and explain the guardianship process here in Utah. Now, guardianship is a legal status that gives authority to one person over another person. It means that one person is able to make decisions for another person regarding things like medicines and other medical decisions, end-of-life decisions, finances, and housing. It's kind of akin to a parent-child relationship. Now, there are really two different types of guardianships here in Utah. There are guardianships over minors and there are guardianships over incapacitated adults. And I wanted to talk about incapacitated adults today. There are really two main situations in which guardianship is sought by families. The first is when you have an incapacitated or intellectually impaired minor that turns 18. And usually the parents will come in and ask for guardianship over that minor, because that minor really isn't able to make adult or executive decisions, and they need some help. So they need to continue that parent-child relationship. So that's the most common situation. Another really common situation is when parents begin to age and they get Alzheimer's or dementia and aren't able to care for themselves anymore and aren't able to make good decisions, especially with money. They're often taken advantage of financially. So the children will come in and ask for guardianship over their parents in order to help them out, make sure the money isn't squandered, make sure that everything's okay. So those are the two kind of primary situations in which guardianship is sought. Now, the first thing that must be proved in a guardianship is that the person is actually incapacitated. And the way we do that is we have psychological evaluations, we get those, and we get doctor's letters. Now, psychological evaluations are usually pretty handy. When children have intellectual impairments, they almost always have psychological evaluations from schools or from doctors that we can utilize. And they don't have to necessarily be recent. I've used psychological evaluations that were up to 10 years old. The doctor's letters, we go to the treating physician of the person, we ask them for a quick letter stating this person has these diagnoses, I've seen this person for this long, and they need a guardianship, they need help, and this person is appropriate to have a guardianship. So we get those together, we put them into pleadings, we give those pleadings to the court. We also have to prove that the person requesting the guardianship is proper. And people who are proper are usually spouses, siblings, and parents. Those are the most common three. So once we've proved all of that, we give that to the court schedules a hearing. And we go to the hearing. If the documentation is correct, the hearing usually takes about 1 minute here in Salt Lake City. It can take longer in Utah County or up in Ogden, but it's usually less than 5 minutes. If there's no objection made and the pleadings are in order, then the guardianship is granted, and we go get some paperwork for the family proving that they are now the guardians, and we're done with the process. So hopefully that explained the guardianship process here in Utah. If you need any help with that, we at Brown Law do quite a few of these, and we'd love to help you out. Thank you.